Good morning, you're Naquinda Niclease.
Judge, you're going to ask me this at sentence, I'll go ahead and explain now. The reason it's now a probation offer instead of a 10-time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court. He's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. I need your signature. And are we going on count one only?
Yes, Your Honor.
Okay, you're Naquinda Niclease?
Yes, ma'am.
And will he waive the formal reading of the indictment?
He does, Judge.
Mr. Niclease, in cause number 24, DCCR 0478, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Niclease is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Obviously, you've been doing very well and following all of those bond conditions. Continue to do that. You shouldn't have any issues. And then we'll see you back at sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's at that desk right there. Okay? We'll see you back.
Thank you, Your Honor.
Thank you.
You go off.
Yeah, give me a house. Good morning, sir. You're John Martin.
Yes, ma'am.
And Mr. Martin is charged in cause number 25, DCCR 0583, with injury to a child, elderly, or disabled individual. And Mr. Burbank, what is the announcement?
I believe the state and I are looking for some CPS workers. Is that right?
I don't see that there's been an order for those yet.
There hasn't, Judge. I'll get one filed. I needed to talk to Mr. Burbank to see if he already has one. He does not, so I'll be sure.
Okay, yeah, let's get that done quick because it takes a while, it seems like, on some of those. I'll sign that order as soon as it comes through. Let's go ahead and just do a 60-day reset because obviously it'll take a little time once I sign that for those to come in, but hopefully they'll come
They
in.
may have them over on the civil side, upstairs.
Okay, all right, yeah, if we can get on that way, that'd be great.
If not, I'll reach out to Miss Adams. She
Okay.
usually gets them to me.
She is. Thank you. All right, Mr. Martin, stay in touch with Mr. Burbank. He'll let you know when you need to be back. You're free to go, sir. Yes, thank you.
Thank you.
Yeah, question.
Okay. I'm sorry. Give me 1 second. I forgot to write this on down. Count one. If I don't do that now, I'll forget. And this is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory? All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that we
Okay.
wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants to have psych evaluation because he does have he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the golden holster and took him into custody. It was, and so
just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information, that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have a no unsupervised time with the child. Are they still together?
No, this happened last year. So they co-parent. I talked to her last week. So she said she didn't want the no contact. So that was our issue because I talked to her and she was like she doesn't agree with that because they co-parent well and she's in school, so he has the child while she's in school. But Mr. Coleman said he talked to her in June, and so she did tell me. She said, well, at the time they weren't on very good terms, so she might have told Mr. Coleman she didn't want. But now she said they are on good terms, and so that was our issue.
I've got notes in my file contradictory. I'm not doubting what
She
Ms.
said,
Holmes'
yeah.
version is today, as we stand here today, but I have a different version based on my conversation back in August of 24.
Oh, that's a whole year
with the
ago.
complainant.
Okay, so the
And
August
she's
of
not the
24.
complainant. She had nothing to do with
She's
this
not.
case.
Well, mother of the child.
Yeah. So she had nothing to do. Like she wasn't on the scene.
Well,
She wasn't.
Is she
Since
here?
we're doing a
No,
lot of
she's
this-
not.
Since we're talking a lot about extraneous things, Judge, and what other people said and say, she did tell me back in August of 24 that the defendant has a history of being harassing and threatening with regard to her. So,
But you haven't heard anything since then?
no, ma'am.
And that was a year ago?
Yes, ma'am.
Can I say one thing, Judge?
Yeah.
I do get my son every other weekend since this incident has happened, so, and we haven't had any issues. I talk to my baby mother every day. My son actually started school this year, so that's.
But y'all aren't still, you and the mom aren't in a
We're not
relationship?
together. We're more of like friends. We decided we couldn't be together.
I mean, the fact that it's been a year and they've been doing that, I feel like that's probably okay. So let's, but I do think even though, let's do a PSI though, but I'll allow things to continue as they have been. And then, have you been receiving any treatment for any diagnosis
I did
that
go to
you?
spinal tap and I did get prescribed some medicine. I got prescribed some sleeping medicine, some bipolar medicine, and antidepressant medication.
And are you taking all that regularly?
No, ma'am, not currently.
Well, that causes me concern.
Yes, ma'am.
So,
I haven't been on it more than 6 months.
why?
I'm having transportation issues getting back to spinal tap.
Okay. How do you get your child? And,
My baby mom will drop him off to my house.
okay, you're gonna have to go to, because of the nature of what you're saying that happened, and even though if she was under the influence, if there were some threats that had to do with that and some mental health issues, then at least and we can do as quick turnaround as possible on a PSI. I am going to have only supervised visits between now and then. You need to get back to spinal tap when you come back for sentencing. You need to show me that you are cooperating and doing everything and following any treatment that they say, because it's going to be a part of your probation now. So you need to figure out a way to get there. You need to figure out, they'll help you with medication, whatever it is. And I want to know what you're on, what you're taking and that you are following through with everything so that I know that you are in a good place, so that your child's in a good place, because we don't need to go back to what happened. So for now, you're going to be supervised only. So if you have someone that can supervise, great. If not, you just might have a couple of weekends that you go without, but we'll do it as quickly as possible. So let's go ahead and go through the plea then.
Yeah, because your mom.
Do y'all didn't do paperwork already
I
though?
have it here.
Okay, yeah, I'll hold it while y'all get that
So
done.
what
I'll
do you want
recall
me
it.
to- Because I didn't put as far as the agreed recommendation, him having no contact with his.
You don't have to put it as an agreed recommendation. I'll order it.
No contact?
Judge, what I intended with the states, I recognize for the purposes of child exchange, there has to be some type of working.
Oh, yeah, I'm not worried about the contact with her. That doesn't seem to be an issue. It doesn't sound like that was an issue in the underlying part, so I'm not going to order no contact with her. I'm going to order supervise with the child, because it
Okay.
sounds like that is what the underlying offense had to do with, not her.
Okay.
So y'all can either agree to mark it off, or I'll do it when it comes through. If you want to argue for it, that's fine, Mr. Coleman, but no, I'll allow him to have contact. You can have phone conversations with your child. You can FaceTime between now and then. I just don't want if there's a supervised, y'all could if you can go somewhere, go to McDonald's, meet her there, have breakfast or lunch or something. No unsupervised. So I'm not saying you can't see them, but you just have to have somebody appropriate supervising until I get some more information. Does that make sense?
Yes, ma'am, it does.
Okay, and it can be her. If y'all are getting along, it sounds like that's not an issue.
Yes, ma'am.
But I would say it's not going to be at her house. I want y'all to be somewhere public. That's not a good idea. Okay.
Yes, ma'am.
Y'all go take care of that paperwork and
So
I'll
what
take
do
care
I-
of it. Y'all,
What do I put as a condition, as a probation condition, supervise it, or?
no, because that's going to be a bond condition.
Yeah.
I'll say it when y'all
Okay,
come back
okay,
up.
Okay, so I won't write it in, okay.
Yeah.
I guess right now.
Just have to see, yeah, y'all can go over that paperwork and then I'll
Okay.
recall it in just a minute.
This is the forfeiture.
Okay, I just didn't know if you want to hold on to it.
Yeah.
Okay.
I just sent it to you.
Good morning, you're Anthony Williams. And Mr. Williams, this is cause number 24, DCCR 0401. You were previously in court, entered a plea of guilty to evading detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Mr. Smith?
Yes, Judge.
Any additions or corrections?
Not from the state.
No, Your Honor.
All right, then, Mr. Williams, I am going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but I'm going to suspend that and place you on probation for 7 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence, while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, and you could be looking at that 10-year sentence that you were already agreed to. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right? Just have a seat here in the courtroom. Probation will call you when she's ready to go over your paperwork. Good luck to you, sir. Good morning. Are you Reagan Benoit?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Benoit, in cause number 25, DCCR 0880, you're charged with the state jail felony offense of attempt to take a weapon from an officer from June 1st of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 25, DCCR 0881, you're charged with, let's see, are we going on the Count one only in that case?
Is that the one we're doing 6 months on?
6 months was on the web, and it's 2 years on
This is the TDC.
This is the two TDC. I mean, yes, Judge, we'll abandon that.
Okay, let me pull this up.
So we're doing 6 on attempted.
the 6 on each, 2 on. So,
Okay. All right, so in 25 DCCR 0881, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a security officer from June 1st of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
no objection.
It's admitted in each case. Is there any evidence that Mr. Benoit is not competent?
No objection.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25 DCCR 0880, find sufficient evidence to find you guilty, and at this time find you guilty of attempt to take a weapon from an officer. Sentence you in accordance with your agreement to a term of 6 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0881, I'll find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to and these cases will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. And firearm is, I have to read the whole thing to you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You go back with the bailiff.
Thanks, Judge.
This is Miss Malfino's case. Aaron Shetley. Good morning, sir. You're Aaron Shetley. And Mr. Shetley, in 24 DCCR 0776, is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Judge, we just need a reset. We're still going through the discovery in the case. So if we can just have a little bit of time to finish that.
It looks like you guys were hired. Yeah, just hired August 20th, it looks like, so,
We'll
okay.
visit about it for the next topic for sure. I've already sent him everything. I want to make sure he feels like he's got it.
Okay, I'll just do a normal reset. Mr. Shetley, make sure you stay in touch with your attorneys, and they'll let you know when you need to be back. Y'all can also visit about all the information that they've received and what any options are, all right? Thank you, you're free to go. Thank you, Mr. Walker.
Max, you Judge?
Yes, sir. All right, sir, you're James Rucker.
Yes, ma'am.
And Mr. Rucker, in cause number 24, DCCR 1348, is charged with violations relating to hazardous waste and it's a third.
Mark Garcia.
The punishment range is that of a third-degree felony in that one, which is between, if you're found guilty, between 2 years and up to 10 years in prison. Do you understand? And then in cause number 24, DCCR 1349, you're charged with theft of property. which is a state jail felony, and that's from May 18th of 2022. And then what that means is if you get found guilty in that case, the range of punishments between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
In each of these cases, I have plea bargain rejections here with your signature on them and Mr. Galmore's that shows that the district attorney's office has made offers if you wanted to enter a plea of guilty in your cases. In the violation of relating to hazardous waste, they've offered, it looks like, is that a 6?
Oh, no, I didn't put the year, sorry, Judge. It was short. The deal was for a short term of deferred probation.
So it's for a deferred probation that would be up to me, and I guess, which is obviously you've gone over with Mr. Galmore, type of probation where you don't have a felony conviction on your record. And then, is it the same in the other case? So you would be, if you wanted to plead guilty, it would be deferred probations in each of those cases with the term and how long that probation is up to me with input from everyone, of course. You have every right to reject those offers and have both of your cases set for trial. I do want to make sure you understand that what your possible consequences are if you go to trial, what your options are if you wanted to enter into those agreements. And do you understand all of that? And do you want to reject those agreements and have your case set, both cases set for trial?
Yes, ma'am.
All right. And is there any reason, I mean, obviously, I can't imagine that the offer would get better. Ms. Malfino?
It's a Mr. Shearer's case, Judge. I don't have any reason to believe that that offer would change. I know they've discussed it for quite some time. I want to
Yes.
make sure that it's on the trial docket that he's prepared.
So I do typically make sure, unless there is new evidence that comes up that either Mr. Galmore or Mr. Shearer does not know about, or something has changed, I will not accept these plea agreements after today. And so if you change your mind later and want to enter a plea of guilty, it would be to some other plea agreement or open to the court or something like that. Do you understand?
Judge, just for the court's perspective, this case had a restitution in the amount of approximately $100,000. That's been reduced to approximately $13,000 now that the financials have been sorted correctly.
Okay.
I believe this is a situation where it'll either require trial or it would be dismissed for restitution.
Okay, so not a restitution paid out over probation. Okay, all right, then, obviously, if that happens before, then the cases get dismissed, and that's another way for them to get off the trial docket, but other than that, we'll let a jury decide. All right, you're free to go. I'll set it on the trial docket. Thank you.
Drayton Rose.
Good morning, sir. How are you? Good morning. You're Glenn Hicks? And Mr. Hicks was previously in court. This is cause number 25 DCCR 0369. Entered a plea of guilty to the third-degree felony offense of assault family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, Mr. Hicks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And if you successfully complete the probation, at the end, the case gets dismissed. The other side of that, though, is if you violate any condition of probation, when you come back, you could be brought back into court, found guilty of the offense, so you would be a convicted felon, and you could go to prison for anywhere between 2 and up to 10 years. Do you understand?
Yes, ma'am.
I want to make sure you understand that you are also, part of your probation is not to have any contact at all with January Corpus. So I don't know what the status of that relationship is, but it's over if it's not already. She cannot give you permission to violate this order, okay? So she can't say, it's okay, I want to get back together, or anything like that. You cannot contact her in person, you can't have communication on your phone or Snapchat or whatever it is. Do you understand?
Yes.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to just have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. Good luck to you, sir. Give me a sec. Good morning. Are you Christian Kane?
Yes, ma'am.
Okay. We're going to lesser.
Yes, Your Honor.
This is cause number 24, DCCR 1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial, sent to the John Donne Behavioral Science Center for competency restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from Dr. Liberis with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
All right, then at this time, based on the two reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24 DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, sir.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Morning, sir. Is it Morrell or Morelli?
Morrell, actually.
Morrell. Well, I was all wrong. All right, Mr. Morrell, did you get someone hired?
No success. I've been to 4 different attorneys.
Who have you talked to?
I've talked to James Macon, Mel Shalander, and J.T. Haynes.
Okay.
And the fourth one was Miss Perazzo, I think. I don't call her and everything, but she was in court, so I didn't actually have
Gotcha.
contact with her.
Okay.
Yes.
And so are you working?
I'm working, yes, ma'am.
Where you work?
Monroe's Cleaners.
Okay. And so as far as being able to afford or saving up, are you trying to work towards that?
I'm working toward it, but no success because I have an excessive amount of bills to pay, and I can't split the difference.
So what I'm going to do this morning is have you fill out some paperwork to see if you qualify for a court-appointed lawyer, since you did what I asked you to do.
Yes, ma'am.
Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
If you step in front of the clerk, she'll give you that paperwork.
Thank you.
Yes, sir. Good morning. Are you Maria Garza?
Yes.
And Ms. Garza, this is your initial appearance in cause number 25, DCCR 1008. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 15th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I was told that they had gave me attorney Courtroom.
Right, and so while you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, I'm going to expect you to try to hire your own lawyer.
Okay.
So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk right here. She'll give you a reset. Just sign this first, and then you can grab it on your way out.
Ready? We want to try you. We'll take a list.
All right, sir, your Tejuan Mac.
Yes, ma'am.
And this is 24 DCCR 1046. Mr. Mack's charged with criminally negligent homicide, set for trial to begin with jury selection Monday, the 29th. And what is the announcement?
That's right.
State's ready, Judge.
All right, I do want to make sure that after today, y'all understand that I will not accept plea agreements.
Understood.
And it's likely to be pretty high up on the list, depending on the other cases. Mr. Mack, you want to go forward with your trial on that date, is that correct?
Yes, ma'am.
We
Okay.
requested a speedy trial.
Well, it's
I understand.
set in 2 weeks.
I know, but as far as the trial order, we have requested this.
I understand. The other case, though, is a child case, which would take precedence if that one in fact goes, but this likely to be probably the first backup to that, potentially. So
So you
we'll
want
see
him-
what else I
I
have.
think there's Batiste on there, Judge. I think he may be in custody.
Oh, he is.
It's somewhat of an old.
It is actually, so here's the thing, I will number the cases tomorrow. Stay in touch with Mr. Kimmler. He'll know tomorrow after my docket what the trial order is and when you need to be back. Okay? All right. Good morning, you're Marquise Berry? Speak up. And Miss Berry, were you able to get a lawyer hired? That's right, I remember now. Okay. So what this says is that you don't have any complications that would require you not to work with some certain parameters. So you're not on bed rest. For who? Have you tried?
I was working at Oregon's High Group before I had stipulations. They let me go due to the fact that I had all those stipulations.
Okay. All right, so I'm going to have you fill out some paperwork this morning, Miss Berry, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. Step in front of the clerk down there, she'll give you that paperwork.